everyone, and welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Martin Atojoko with us, experienced barrister with solicitor of the Supreme Court of Nigeria, and an author with a demonstrated history of working in the law practice industry. Skilled in international contract drafting and review, international taxation, international arbitration, negotiation, transactions, real estate litigation, legal research, lawyers management, innovation strategy, coaching, mentoring, and public speaking. I have so much to talk about him, but I think it'll make a lot of sense if we can have the man himself talking about himself. All right, so let me quickly introduce you all to Martin himself. Hello, Martin. How are you doing today?
I'm fine, and you?
Doing very well. Thank you so much for asking. All right, so it's a pleasure to have you on the show, Martin. And I think the first thing first, we all would like to know about yourself in your own words. So if you can please brief us about your journey as a legal professional so far.
Okay, my name is Martin. I was called to the Nigerian Bar and the Supreme Court of Nigeria as a solicitor and advocate to practice law. Out of my passion for study of law, I have been opportune to have taken further studies and LLM International Business Law from the IE Law School and Northwestern Chicago as my further studies. I've done a couple of research work and I've written quite a lot of publication on privacy law and other aspects of law.
All right, so thank you so much for sharing that quick insight about yourself, Martin. Let's quickly jump on to the first question now. And this question is about one of the most complex legal issues that you worked upon. We'd like to know if you can help us to understand the complexity and tell us how did you approach it?
Okay, thank you so much. As a real estate expert, I had this instruction from the bank to register a deed of legal mortgage. A facility had been advanced to a client of the bank, and they had wanted to register their legal mortgage and create a legal interest on the property. But we had this issue of conflict in signature, and that the bank had no opportunity to verify and compare signature at the land record before they had gone into the transaction. Unfortunately, the signature was in conflict with the original signature that was given to the bank. So we had to approach the Land Registry for the registration, and they declined the registration on the grounds that the signatures was in conflict. And the question was this: did the bank had opportunity to verify and compare the signature before they went into this transaction? The answer was no, absolutely no. But what the bank needed to do by conducting legal search at the Land Registry, they had done it, which was in conformity with the law and provisions of such transaction. But we could not proceed because of the signature variation and the mortgage was already going bad. So what do? We had to do a position paper to the land registrar explaining the position that the bank have not have the opportunity to have verified the signature amounts to non-liability on the bank. Therefore, they had to go ahead to register the mortgage. So we had to do a position paper and an opinion to the land registry saying that, look, the mortgage facility is going bad and the bank cannot transact further if the legal mortgage is not created. So since the bank did not have opportunity to have access to the signature of the mortgagor before the transaction, the bank is exonerated from the liability. So you look at it, compare the signature. If it's in variation, we had to provide the ID of the mortgagor with the bank and compare it with the ID of the mortgagor in the registry's file, and the pictures were the same person, but different signature. So at that point, we did a position paper to the bank, to the land registry, and had to get what we call an indemnity from the High Court, an affidavit of indemnity from the High Court, saying that go ahead, perfect this mortgage, and create the legal interest. Then, if there's any liability as to adverse claim from the mortgagor, we will take responsibility. And the land registry went ahead based on our indemnity and a position paper we did to them and created the mortgage. And unfortunately, at the end of the day, the mortgage went bad. So the bank had to sell the property.
Oh, okay.
Yeah, the bank has to sell property. And right now, the matter has gone to court. The mortgagor has gone to court to say you can't sell my property. But the bank had won at the High Court. And the matter is currently at the Court of Appeals in Nigeria. So that's most interesting thing I've done in terms of complexity of handling real estate issues. That's just it. Thank you.
Yeah, so this would be one of those. I'm sure there are many more, but this is something. Yeah, this is something which always, that always will stay with you for a very long time because you'll remember this one. And
Yes,
this is not a very common issue, right?
Yeah, it's not a very common issue, but it was a defining moment for the Land Registry as well, and also it created a principle for the banks to always do what they call due diligence, further due diligence before they enter into mortgage. So it's a principle that I have been able to create at the Land Registry, which they've been able to accept as the normal. Since you don't have the opportunity to compare signature, so it's not going to be your fault.
Absolutely, yeah. It should not be your fault if you do not have the capability to do that. Right, absolutely. And it helped them made a principle for the following issues as well in the same nature, right?
Yes, very principle. Yes.
Yeah. Oh, amazing. That's a very good story. That's a very nice story, and I'm sure there was so much for you to learn, to understand. You had to look for, you had to have the eye for a detail. You had to look into minute things and compare things at a very minute stage, and that's how you kind of came up with the right solution.
Yes, you have to look at it, and the extent of liability was also determined because at the time the contract was entered with the bank, that the bank had the opportunity to have known what they should have done. If you don't provide the opportunity for the bank to assess the records of the Land Registry in totality, and you have to wait until you issue a search report saying there's no encumbrance and the bank goes ahead and transact, why do you want to deny liability at this stage? True. So I think that's one of the things that we're able to expatiate on.
Yeah, it was indeed a complex one, and kudos to you that you kind of used your expertise to kind of guide your client in the right direction. Thank you so much for sharing that insight with us on that particular brief. And I'm sure a lot of from our audience, a lot of them would be making notes and would understand how they can really approach such briefs if they happen to be in the similar kind of situations. Thank you so much, Martin, on that particular answer. And let me quickly move on to the next question now. So the next question talks about the pandemic. So we all have been into this for quite some time now, and no one was exception. So we saw a lot of courts moving towards the remote proceedings and availability. We want to understand, in your opinion, Martin, is this sustainable and a possible way to increase access to justice?
Yeah, well, I could say it was I could say it was a matter of necessity, and that access to justice shouldn't be and cannot be restricted. Unfortunately for me, this is quite an interesting question for me because my LLB thesis was on access to justice and question of jurisdiction. That was my research topic. So was something, access to justice and a question of jurisdiction. And so when I saw the topic, I was so glad and said it was something I would like to actually talk about, and I was at the right place. So what I think access to justice means is that people must be able to access justice as at when due, because time is really of essence when it comes to access to justice, especially looking at criminal trials and other aspects, even business transaction, because time is always of essence for such kind of transaction. But to my mind, the remote system, though an added advantage, what I do not think is a totally sustainable and definite attempt to grant total access to justice. Yes, it may be able to assist a little bit. Why I take this exception is because of once you're a litigation lawyer, the component aspect of practice, like the body language when you present a case before the court, is really missing in the remote aspect of this kind of innovation in law practice. You know, when you have to argue your case and submit before the court, most often at times, whether I like it or not, the body language to an extent has an impact on the delivery of justice system. So based on that, you don't have this kind of scenario when it has to be at the remote level. So when I talk to you on at the Zoom meeting we're having now, it's not going to be the same thing that is going to be if we have to have a physical interaction. So the body language aspect of presentation before the court is greatly missing in this aspect. But if it an attempt to try to grant quicker access to justice, I would totally agree that it's sustainable, because aspects of presentation, like you have to take the motions, you have to make little presentation before the court, it's also aid to facilitate that, to make it faster in terms of administration of justice. But when it comes to the final submission of presentation, like adoption of final addresses and cross-examination and other things, those aspects of practice, to a great extent, it's limited in this regard. Thank you.
Thank you so much for sharing your thoughts on this one, Martin. And I think, yes, I agree when you say that meeting digitally versus meeting in person is completely a different feeling and a completely different experience altogether. It cannot be compared. It cannot be compared. And I'm sure when you say, you're the expert, when you say that there are so many legal matters that cannot really be taken forward in the remote proceedings, you're absolutely right. There are so many kind of cases that you cannot really, especially when a defendant has to be physically present in the court. You can't do that on a digital proceeding. So thank you so much, Martin, for sharing your thoughts on this one. I'll quickly move on to the next question of the session, which talks about, it's a question about how do you rate the current legal system drive towards encouraging access to justice? Do you think there is a tangible movement in closing the justice gap?
Well, like the issue of access to justice every day, because of the complexity of commercial transaction, high rates of crimes around the various jurisdictions. There's huge volume of work with the courts system, that the courts are quite limited in number, sometimes due to the constitutional provisions or laws setting them up in some jurisdiction. So when you have, for instance, the jurisdiction under your constitution provides for some level of numbers of court. For instance, let me say 20. If a court cannot be more than 20 in the jurisdiction, and is that in the constitution or it's in the laws? And you see that daily, because of the complexity and the innovation going on around the world, there's a lot of issues with commercial transaction, breaches of contract, business investment, interpretation of agreements. So because of the volume of issues coming out these days, it's really straining on the judiciary, which is supposed to be the custodian of administration of justice in most jurisdictions. So because of this rise in activities, access to justice is greatly being limited lately, because everybody needs to be heard, and it has to be heard one after the other, first in time. So that's the greatest challenge that I think is really limiting access to justice in the whole world right now. It's all over the world. It's not only in my own country, in the United States of America, I don't know, all over the world, because of the extent of volume of transaction, interaction, there is huge body and limited access to justice. I must say that. Yes, that's my position.
Yeah. I think you're absolutely right, and I keep hearing this from a lot of leaders in the industry from different countries, that yes, there is still a huge gap. All right, thank you so much for sharing your thoughts on that particular question as well. I'll move on to the next question, Martin, and this time let's talk about the legal technology a little bit. So in the era of legal technology, what are the most commonly used tools for you, Martin?
Wow, that's a beautiful one. The most used technology for me remains the internet. The internet, using the email more particularly. And it's more interesting to me, and it's a topic that I'm quite interested in because of the little innovation and change in the Nigerian legal system, amendment of the Evidence Act, Nigeria's Evidence Act. Before now, the Evidence Act was not admitting electronically generated evidence. That was the position of the law. But with the amendment of the Nigeria's Evidence Act, you could really rely on evidence generated from the emails, generated from other sources of the legal tech, what do you call it, the technological tools in administering legal transaction. What you just need to do, according to the new amendments in our laws over here in Nigeria, it has a section 48, section what we call section 48 of the Evidence Act. What it does is to tell the court, to post a statement saying that the document was printed from a computer, or the picture was printed from a camera, which was functional at the moment, at the point which you printed it out. So to be admitted as in evidence. So because of this innovation and change of law, admitting that documents printed from the computer, emails, it makes it more interesting these days for you to be able to be more frequent in using the emails. But before now, you will have to send the document. It has to be duly acknowledged physically before you can tender it in court and become generally admissible. But with this innovation, it has made email, using of email, more interesting to more legal practitioners in our jurisdiction. Since now, use of email is more convenient for you and is generally acceptable. A transaction on email, a message, a mail downloaded from your computer and attached as exhibit in court, as long as you conform with the provisions of the Evidence Act, it's now generally admissible. So it makes the use of email more frequent for me these days. Thank you.
Absolutely, and I think this is convenient, this is efficient, and this is eco-friendly as well. Let's not forget that.
Yes, and faster and
faster. Yes, yeah, it's faster, convenient. That's absolutely right. All right, Martin. Yes. I think this is definitely a tool that almost everyone uses in today's time. And but yeah, you kind of pinpointed the benefits of using this and how you can use it more efficiently, which is great. Thank you so much for answering that question. With that, we come to the end of this session, and we just have the last question. The last question is about time is money in any profession, right? And in legal, it's most of all. So, Martin, how do you ensure to make the best of your time as a lawyer?
Perfect. Well, it's quite a difficult question, and very dynamic. Time is the greatest essence of what we do, not only as lawyers and as human beings. What I try to do in terms of time is I try to limit physical instruction with our clients these days. What I do is I try to tell you, okay, send us an email, and we will deal with it as soon as possible. Because sometimes you have to be in the court. Sometimes there's an instruction waiting for you from a client. So you now have to do an alternative way of trying to do two things at the same time. Like send an email, send a WhatsApp message, leave a text message. So in that aspect, you can now manage your time and have access to more clients. Because whether you're in court, you are being paid. Whether you respond to a client online, you are being paid. So at that level, you can now use reasonable time to manage your client and earn more money. Yes.
That's a beautiful answer to a very important question. And I'm sure a lot of our viewers would be making note out of that and learning the best practices. So with Martin, with that, we come to the end of this quick conversation that I had an opportunity to have with you. Thank you so much for sharing all those great insights. And I'm sure there is a lot of value add that you're doing for our viewers as well in terms for them to learn from your experience. So for our viewers, if you like this chat with Martin, please like and share this video with your colleagues, with your family members, with your fellow partners or fellow colleagues in the business. It should help them as it is helping you. And Martin, thank you so much once again for sharing those great insights. We would love to have a chat with you once again in the future on some other trending topics in the legal fraternity. Till then, this is Vinay signing off for LexTalk.